If you have dual citizenship, or you are planning to become a U.S. citizen, you have probably seen the same headline popping up everywhere. Breaking dual citizenship law changes in February 2026, plus talk of a DHS dual citizenship registry, tougher border screening, and stricter tax enforcement. Here is why this matters. The U.S. is a country where travel, paperwork, and consistency are everything. And when a viral claim mixes real concepts like CBP screening and IRS reporting with unclear new requirements like a registry and a registration deadline, people panic and make bad decisions. By the end of this video, you will know 3 things. 1. What dual citizenship actually means under U.S. rules today. 2. Who would realistically be affected if any new process shows up and who would not. And 3. A practical checklist for what to verify, what documents to gather, and how to avoid the mistakes that trigger delays, secondary inspection, or extra questioning. Now, before we go further, I need to be very clear. The brief you are seeing online talks about specific new requirements, including a DHS dual citizenship registry and a deadline to register by August 1, 2026. As of right now in this prompt, we do not have an official document to cite. So I am going to treat parts of this as reported or unverified claims, and I will separate what is generally true in U.S. law from what would require official confirmation. Here is the part most people miss. Even when a viral claim is wrong, the fear it creates can still cause real harm because people rush into travel, passport, tax, or filing choices without a plan. So let us start with basics, because clarity is power here. In plain English, dual citizenship means you are recognized as a citizen by 2 different countries at the same time. The U.S. government has long dealt with dual nationals, and the U.S. does not have one single application called Apply for Dual Citizenship. Dual citizenship usually happens because of how citizenship is acquired: birth in the United States, birth abroad to a U.S. citizen parent, or naturalization. It can also happen if another country gives you citizenship through descent, marriage, or naturalization while you keep U.S. citizenship. Myth versus reality number 1. Myth: the U.S. bans dual citizenship. Reality: the U.S. generally tolerates dual citizenship, but it expects you to follow U.S. laws, and it treats you as a U.S. citizen when you are on U.S. soil. Another myth: if you get another passport, the U.S. automatically takes your citizenship away. Reality: loss of U.S. citizenship is not automatic just because you have a second nationality. It is a serious legal process, and it typically requires a voluntary act plus intent, and it is not something that happens overnight to millions of people because a headline went viral. Now, what could actually change in February 2026 if anything changes at all? In general, changes could come from new agency procedures, expanded information sharing, updated screening guidance, or enforcement priorities. And that is why you keep hearing terms like registration requirements, enhanced border screening, tax enforcement, and foreign military service risks. Many of those topics already exist today in some form. They are just not always explained clearly. Here is what we can talk about with confidence, because it is generally true regardless of rumors. 1. Border screening and secondary inspection already happen, and CBP can ask questions to determine admissibility for non-citizens and to confirm identity and citizenship for citizens. 2. The U.S. tax system already expects U.S. citizens and many green card holders to understand U.S. tax obligations, and FBAR is a real reporting concept for foreign financial accounts, with real penalties when people ignore it. 3. Foreign military service and certain foreign government roles can create real complications for security clearances and sometimes for immigration benefits, depending on facts. None of that requires a brand new February 2026 law to be relevant. But what about the specific claim of a DHS dual citizenship registry and a requirement to register by August 1, 2026? This is where we need to slow down. If you see a hard deadline and a new registry, do not assume it is real until you can verify it on an official government source. This is where people get denied or delayed. They act on a claim, fill out the wrong forms, pay third-party services, or submit unnecessary documents that create inconsistencies. So let us organize this by who would be affected versus who likely would not, because that is what you came for. First bucket: U.S. citizens who already hold another nationality and travel frequently. You are the group that would feel any new screening procedures the fastest. Not because you would lose citizenship, but because your travel patterns, document consistency, and answers to questions are where friction shows up. If new screening guidance increases scrutiny on dual nationals, the practical effect is more questions, more secondary inspection, and more requests to clarify your ties, your residence, and your travel history. Second bucket: green card holders planning to naturalize. If you are filing for U.S. citizenship, you are already in a process where you must be consistent about addresses, travel history, selective service where applicable, and any criminal or immigration issues. If a future policy shift focuses more on foreign ties, foreign employment, foreign military service, or foreign financial arrangements, naturalization applicants are a group that could see more detailed questioning. Again, that does not mean denial is automatic. It means preparation and consistency matter more. Third bucket: parents with children born abroad and families dealing with passports. This is an area where confusion is common. Some children may be U.S. citizens at birth, depending on the parents and physical presence rules, but they still need the right documentation. If procedures tighten or if identity verification becomes more strict, families could see longer processing times or more evidence requests for things like birth certificates, parent citizenship evidence, and records showing the parent lived in the U.S. for the required period. Here is the key: this is about paperwork and proof, not about a new ban. Fourth bucket: people with sensitive jobs, government roles, or security clearances. Even today, dual nationality and foreign contacts can be a factor in security clearance adjudication. That is not the same as immigration status. But if you are in a job that requires a clearance, or you are applying for one, you should expect more questions about foreign passports, foreign benefits, foreign voting, foreign military service, and foreign financial ties. Higher scrutiny in that world is not shocking, and a rumor can spread because it feels plausible. Now, who is likely not affected in the dramatic way social media suggests? Most everyday U.S. citizens who hold another nationality and live a normal life are not going to wake up in February 2026 and lose their passport. Most lawful travelers are not going to be blocked just because they are dual nationals. Most families are not going to have their immigration petitions canceled because a parent has a second passport. The real world is usually more boring: extra questions, more documentation, and more delays for people whose facts are complicated or whose paperwork is inconsistent. Here is the second myth versus reality moment. Myth: dual citizens cannot use a foreign passport at all. Reality: when entering the United States, U.S. citizens are generally expected to enter as U.S. citizens, typically using a U.S. passport. When leaving or entering another country, that country might expect you to use its passport. The practical issue is not that you have two passports. The practical issue is mismatched names, expired documents, or travel records that do not line up with what you declare. Now let us talk about the registry and registration concept carefully. If a government created a registry, the most likely purpose would be data collection, identity confirmation, and cross-agency coordination. But you should treat any third-party site offering registration help as a red flag until you verify it is official. If such a program were real, you would expect to see clear public guidance, an official webpage, and instructions on what information is required, what the legal authority is, and what happens if you do not comply. Without that, it is just noise. So what should you do with the claimed deadline, August 1st, 2026? Here is the safe approach. Put it on a watch list, not on a panic list. Build a verification routine. Check DHS and USCIS official updates. Watch for official Federal Register notices if a rule change is claimed, and follow official CBP travel guidance pages. If you cannot find it there, assume it is not confirmed. This is the part most people miss. Your best defense is not guessing. It is documentation and verification. Next, let us address enhanced border screening, because that is real in the sense that CBP already has broad inspection authority. What does enhanced screening usually look like in the real world? More referrals to secondary inspection. More questions about your purpose of travel, where you live, and how long you have been abroad. More requests to unlock devices in some cases. And more emphasis on consistency across your answers, your travel history, and what is in government databases. If you are a U.S. citizen, CBP cannot deny you entry the same way they can deny a visitor, but they can delay you, question you, and refer you for additional checks to confirm identity or deal with law enforcement flags. If you are a green card holder, CBP can evaluate whether you are returning as a resident and whether you may have abandoned residence based on long trips, foreign residence, or other facts. Here is a small detail that changes everything. The same travel pattern can look normal for a U.S. citizen and risky for a green card holder. Now, passports and renewals. A lot of people assume passport issues are only about expiration dates. In reality, passport problems are often about identity, name mismatches, missing proof of citizenship, unclear parental relationships for child passports, or inconsistent biographic data across countries. If you are a dual national, review your documents for consistency now. Are your names spelled the same? Do you have the same date of birth format? Do your marriage and divorce records match the name you use on your U.S. documents? Fixing these things takes time. Let us bring in the tax and FBAR part, because this is where fear content goes viral. The brief claims stricter IRS tax enforcement and FBAR compliance focus for dual citizens. Here is the plain English reality. U.S. citizens generally have U.S. tax filing obligations regardless of where they live, and certain foreign account reporting can apply depending on your situation. FBAR, as a concept, refers to reporting foreign financial accounts when you meet the threshold, and it is separate from your income tax return. I am not giving you tax advice here, but I am telling you the risk. People get in trouble when they assume that living abroad or having a second passport means the U.S. cannot see their accounts or does not care. Enforcement priorities can shift, and information sharing can increase, and that can create compliance pressure. Here is myth versus reality number 3. Myth: if you have money overseas, CBP will seize it at the airport because you are a dual citizen. Reality: border screening is not the same as tax enforcement, and most travelers never face anything like that. The real risk is that you ignore your reporting obligations for years, then you apply for a benefit, renew a passport in a complex situation, or go through a background check for work, and the inconsistency forces you to deal with it under pressure. Now, foreign military service and foreign government roles. The brief mentions risks here, and it is true that foreign military service can be a sensitive fact depending on the country, the role, and any associated security concerns. For immigration processes, it can raise questions during background checks. For security clearances, it can raise mitigation questions, foreign allegiance, foreign preference, foreign influence. If you have this in your history, the best move is not to hide it. The best move is to gather records and be ready to explain it clearly, truthfully, and consistently. Let me give you 2 example scenarios so you can see how this plays out. Example Scenario 1. Maria is a dual U.S. and foreign citizen. She lives in the U.S. but visits her other country twice a year to help an elderly parent. She sees the February 2026 headline and panics. She considers traveling only on her foreign passport to avoid attention. That is where people create problems. The safer approach is to keep her U.S. passport current, make sure her names match across documents, and keep a simple travel log. If she is ever asked, she can explain her travel pattern calmly, with consistent dates. Example Scenario 2. Ahmed is a green card holder planning to file for naturalization. He spent long periods abroad for work, and he has a foreign bank account he uses to support family. He is not sure what FBAR is, and he is worried the new rules will block him. The real-world move is to pause, get organized, and verify what is required for his tax and reporting situation with qualified help if needed. Then file confidently with consistent addresses, travel history, and documentation. Rumors do not help him, preparation does. Now we get to the practical part. What to do now in a do this and avoid this format. Do this. Verify before you act. If you hear there is a new DHS registry, look for it on an official DHS, USCIS, or Federal Register channel. If it is not there, do not submit personal information to random sites. Do this. Keep your U.S. passport valid if you are a U.S. citizen. If you have travel coming up, do not wait until the last minute to renew. Do this. Align your identity documents. Make sure your name, date of birth, and place of birth are consistent across passports and key records. If you changed your name, keep certified copies of the documents that explain the change. Do this. Keep a travel history log. A simple spreadsheet with entry and exit dates, countries visited, and the purpose of travel helps with naturalization forms, passport issues, and any future questions. Do this. If you are a green card holder, be careful with long trips abroad. If you regularly spend extended time outside the U.S., talk to a qualified professional before it becomes an abandonment issue. Do this. Organize your immigration file. Save copies of prior applications, approvals, and notices, plus your current status documents. Many delays come from not having your own records. Do this. If you have foreign military service, foreign government employment, or a security clearance issue, gather documentation now and be prepared to disclose it accurately. Do this. If you have foreign financial accounts, learn the basics of what reporting regimes exist and whether they apply to you. Do not assume. If you need help, use reputable tax professionals who understand international issues. Avoid this. Do not rely on a single viral post for legal requirements or deadlines. Many posts mix real concepts with invented deadlines. Avoid this. Do not lie or guess on government forms or at the border. If you do not know, say you do not know and follow up with documentation. Avoid this. Do not create mismatches by using different names, different birth dates, or different address histories across countries and applications. Avoid this. Do not pay anyone who promises to register you in a secret registry or fast-track compliance. If it is real, it will be verifiable and public. Now, what should you watch next between now and February 2026? Watch for official guidance that is specific, a published rule, an agency announcement, a form update, or a clearly posted compliance requirement. Watch for updated CBP travel guidance language about dual nationals. Watch for USCIS policy manual updates if naturalization screening focus changes. And watch for credible reporting that links to primary sources, not just screenshots. If there really is a registration requirement by August 1st, 2026, you will see a clear answer to these questions. Who must register? What information is required? What legal authority requires it? What the privacy rules are? And what the consequences are for not registering? Until you can answer those questions with an official source, treat the claim as unconfirmed. Let us do a final recap, calmly. 1. The U.S. generally allows dual citizenship in practice, but expects compliance with U.S. rules and consistent documentation. 2. The biggest real-world risks are not sudden citizenship loss, but delays, extra screening, and complications from inconsistent records, complicated travel patterns, and misunderstood tax and reporting obligations. 3. Green card holders planning to naturalize should be extra organized about travel history and disclosures. 4. Parents handling children born abroad should focus on correct documentation and early planning. 5. Anyone with foreign military service, foreign government roles, or a sensitive job should assume higher scrutiny and prepare records. Do not panic, but do not ignore it either. Build your document file, keep your travel and identity information consistent, and verify any claimed February 2026 change directly through official sources. If you want, in the comments, tell me your situation in broad terms: U.S. citizen, dual national, green card holder, naturalizing, or parent with a child born abroad. I will make a follow-up video focused on the most common scenarios. And if this kind of calm, step-by-step immigration and travel rules breakdown helps you, subscribe and turn on notifications so you do not miss updates as soon as we can verify them.